Hello and welcome to the third of the King's Chambers Property Team's Pick and Mix seminars for today. We're joined now by Mark Harper QC, who's going to talk to us about experts. If you have any questions for Mark, if you put them in the Q&A box or the chat box, and we'll deal with them at the end. Now, according to the most recent edition of Chambers and Partners, if you want to roll out the big guns, choose Mark Harper QC. So when I was putting together our programme of events today, for today, I thought we'd better see if we could roll him out. So here he is Mark Harper. Over to you, Mark.
Thank you very much, Geraint. Good morning, everyone. I knew Geraint was going to say that, and when I track the person down who says you need to roll me out, their lives will be very difficult, I can assure you. You move on to the next station on the pick and mix. I hope I'm not going to be licorice. I hope I'm going to be one of those nice, attractive jelly sweets with the next 20 to 30 minutes, and very much a practical angle on this talk, because expert evidence has been something I've always been interested in ever since one of my first cases I did, the boundary dispute in Liverpool County Court in front of His Honour Judge Maddox, to dispute over a property in Lancashire as to where the boundary lay. Our expert was an old school, very simple expert. He went along, he saw it was impossible to plot the boundary from the plans. So he went on site, found an original boundary feature, an old boundary post stone. And he said, one thing the plans agree on is it's a straight line parallel between two properties. And he drew that, and that was our expert evidence. The other side came back with about 35 pages of reconstruction of plans, investigations, but no mention whatsoever of the boundary post. And my expert said to me before I was going to cross-examine their expert, ask him about the boundary post, because he saw it. This was in the days before joint meetings. And so I cross-examined the expert and said, you've seen that there's a boundary post on the site. Did you notice that when you visited? And he said, yes. And you'd appreciate it was quite significant. Yes, I did. And you didn't mention it in your report. Well, I did mention it in my report. What do you mean? Well, I mentioned it in my draft report. I said, well, why is it not in your final report? I was told to take it out. By whom? The instructing solicitor. Why did he tell you to take it out? Said it was very damaging to our case. At that point, His Honour Judge Maddox took over the cross-examination and said, do you think you've been compromised as an expert? And it is really illustrates, that's a very extreme example, but it really does illustrate the care which needs to be taken with expert evidence. And the starting point really with expert evidence, we've got on the slides, is really, when do you want to instruct your expert? The first question when you get a case is going to be, do we need expert assistance on this case, whether in formulating it or advancing it at trial? And if so, when do we need to get them on board? Because one of the pitfalls that you do see in cases is that the expert is brought in too late, after you've pleaded the case, after you've gone through disclosure, after you've prepared witness evidence. So the first things to be looking at is, do you need your expert to help assist you with the investigation of your claim, in formulating it, pleading your case? The number of times you get asked to look at a pleading after expert evidence to update it by reference to what the expert says are still on the increase. You're better, if you have a technical case which requires expert evidence, to have the benefit of some expert input when you're pleading your case, in particular on issues of liability. And you can see in a technical property case, that is going to be particularly pertinent. And those of you who practice in the professional negligence arena will be aware that if you're alleging breach of a duty by a professional, then save in a certain exceptional cases, you'll be expected to back up your case with the appropriate expert evidence. Another issue which the courts are becoming very alive to is, gone are the days when the courts are allowing you to plead loss. Yes, as a result of the matters aforesaid, we've suffered loss and damage for particulars of which we provide in due course. There is a practice becoming of expecting a pleading to be formulated with some particulars of loss and damage. So if you do need expert input in relation to formulating your loss and damage claim, then you should be getting it before you're pleading, so that your pleading is complete and is not going to be at risk of an early application to have it struck out or amended, or you'll be able to cope with an early request for Part 18 information in relation to the calculation of your claim. Sometimes expert input can be very useful when considering what documents you're going to want to see from the other side on a particular case. So give a thought as to whether or not you want to have expert input at that stage. Also, as well, leading into Nigel's talk, what's your strategy in this case? Are you looking at a stage of making early offers or going to early ADR? If so, are you going to need expert input in advising you as to the ranges of the values of your claim? All things to be considered as to when you need your expert on board. However, that brings with it probably one of the most overlooked points as regards expert assistance. And I use that term deliberately for the following reasons. Insofar as a party is retained as an expert witness, then that person immediately becomes subject to Part 35. And the most important part of Part 35 is that the expert has to disclose the material instructions that they've received from the solicitor in relation to the opinion that they are expressing. And also, as well, privilege is removed in that regard. That does not, however, apply if you retain your expert to act as an advisor. And we've given on the handout there the references in Part 35 and the notes there too, where paragraphs 4 to 8 of 35 EGB sets out the distinction between expert advisor and expert witness, and the requirements of CPR Part 35 don't apply to the expert advisor. So if you are having early assistance from expert assistant, you're having early expert assistance in formulating your claim, disclosure, or providing advice, that has got to you've got to make sure that that falls under the guise of expert advisor. Now, often if you bring in a person to act as expert advisor, the view will be that you'll expect to use them as expert witness. It is very important that you as solicitors, and also that you check that the witness themselves will have procedures in place so that you're able to point to the point in time when you say the status of the expert changed from advisor to witness. Now, the accepted guidance appears to be that you have separate retainer letters. You have a retainer letter for when the expert is acting as advisor, and you spell out the types of tasks that you will expect them to carry out as advisor, and you will spell out in that retainer how that retainer will be brought to an end. You then have a separate retainer letter for the retainer as expert witness, so that we're clear from that point in time they're acting as witness. Therefore, anything that they are told in relation to the preparation of their report is potentially disclosable as material instructions, and the documents which give rise to the material instructions are potentially disclosable and are exempt from the privilege exemption. It is very important that you're planning this from the outset so that you ensure that your expert is going to have document management processes in place, and you're going to have document management processes in place that really are linked to their role as expert advisor or expert witness. You do not want a blurring of the lines so that the other side can go on an application saying, well, we would like to see what information you received at this particular point in time because we believe you're acting as expert witness. If you can turn around to the court and the other side say, no, sorry, that was covered by this retainer, you're not entitled to it, that's going to make your job a lot easier. The other thing which you need to consider in this regard, and we've there set out the key considerations. One, what you've got to think about is how do we identify and show the point in time when the expert moves from advisor to witness? What procedures will we and the expert have in place to manage the transition? But number 3 is the most important one. It often gets overlooked. You cannot take it as read that your expert will be able to move from the position of advisor to witness. You will expect your expert to consider, and you'll also need to consider, whether or not anything has happened during the course of the expert's retainer as advisor to preclude it acting as expert witness. Has anything happened which could give the risk of undermining independence? In most cases, there shouldn't be anything, but at least you've applied your mind to that, because it's an easy question for cross-examining counsel if they're aware that the person has acted as witness before becoming, has acted as advisor before becoming witness, to say, have you asked that question? And have you considered it? And if they haven't, it does undermine their credibility from day one. If we move on then, other pitfalls with expert evidence. If you have a case where the expert is on board from early days, then there is a real risk that the client in their mind builds up the expert as their expert, and they believe that their expert's role, therefore, is to advance their interests. It is very important, often overlooked in practice, that explaining to the client the role of this expert advisor. Yes, they're acting as an expert advisor at this stage, but they could be in the position that if this matter goes to court and the expert has to produce evidence and go into the witness box to justify that evidence, that expert's primary duty is to the court. And if that's made clear from the outset, it does really manage the expectations of the client. Another thing is managing the expectations of your expert. And I'm informed by this in a case that Leslie led me in a couple of years ago, I think 2012 now, it's that long ago. You've really got to make sure that your expert is on board from the outset. Are they going to be able to commit the personnel and resources to carrying out the expert role? And by that, I mean, you often deal with, especially with the bigger firms, the person who is put forward as the lead expert and who'll be going into the witness box. There's a real risk sometimes that they are seen to be, in effect, going into the witness box to be the voice for work which has been done by somebody else. You have to ensure that your expert, the person you've chosen, that they are going to be fully involved in the work which is carried out, so that they are able to speak to the same. You don't want to, in effect, be paying for expert X and the work's being done by expert Y, and expert X is just going along to speak to it. That is really important. The other thing from experts is there are still experts who come along and think that what you want to hear is the expert evidence which best suits your case. The client wants, in terms of valuation, the client wants to hear the highest values. No, they need to be told from the outset that what you want is realism. What we don't want is a big punchy report which says the claim is worth, say, for instance, 3 million. As soon as they start going to the joint meeting and going into court, they're going backwards on that figure faster than you've ever seen before. You want to know from the outset what is the realistic value of the claim, insofar as there is a range of outcomes on the opinion the expert is expressing. You need to know that, because that is fundamental to your litigation strategy. The client wants to know what are the range of possible outcomes which relate to the expert evidence, so that they can adopt their strategy, in particular the negotiating strategy, accordingly. So really, when at the outset, please don't feel that you should not be telling the expert what you expect from them. No, you should be telling the expert what you expect from them. I'm just in the middle of a case now where we just had this case I've just been brought into, valuation property claim, and the valuer has just turned round and said, "Oh, I'm sorry, I don't think I'll be able to be in a position to carry out this report in the time frame or at all." Now, what you want to avoid that situation is you want to be making sure that your expert is signed up from the outset, knowing what the commitment in terms of work is going to be. And again, they're going to have the resources and time capacity to be able to do with it. I know these seem simple and practical points, but they are very important in the overall operation of expert evidence in the context of litigation. The final point, I think, is the most controversial, and views vary on this, is to what role the expert takes in the team. My own view, and I'll be interested in Leslie, Paul, Nigel and Geraint's view on this, and anyone in the audience, has been that the expert really input into conferences should be confined to those issues where you're going through the expert evidence. I think if they become involved in bigger strategy conferences, there can be a risk that they could see their independence potentially being undermined. But that's a matter of a preference. But it's an issue to always be considered. To what extent should we be involving the expert in this stage of the litigation when they're acting as witness? The other point is, when does an expert need to attend trial? Often you'll have the case, well, the expert doesn't need to attend unless and until it's their slot in the trial timetable. That shouldn't always be safely relied upon. It may be appropriate for the expert to come along and hear certain aspects of lay evidence, which may impact on the opinion they're expressing. Again, always assess for the purpose of the particular litigation. That's very much a whistle-stop tool through some pitfalls which I've certainly come across in expert evidence. I would hope that there's some questions to inform some discussion for the last part of the talk. Thank you very much for listening.
Thanks very much for that, Mark. We've got one question. Alex Stefanovic has asked, it's a question that appeared while you were talking about the distinction between advisors and witnesses, and the pitfalls there. Query incentive-based fee issues for experts.
I think they are. I've got one at the moment where the expert is being paid by the funders on one, and that we believe there's an incentive. I think it undermines the independence. I'm old-fashioned in that regard. The expert should be paid for the job that they're doing to give evidence. There shouldn't be some kind of incentive put forward for that. I don't know if Leslie, Nigel or Paul has any different view on that. Hi, Leslie.
It's Leslie here. Yeah, thanks, Mark, for a really interesting talk. I agree with you on the last point on incentive. I don't see how it can possibly be reconciled with the duty to the court, and certainly there has to be, if contrary to that view you do it, there has to be absolute transparency about it and the term. On your other question of experts getting too heavily embedded into the team, I again, perhaps unsurprisingly, agree with you. I always get a bit nervous when the expert gets really enthusiastic about the case more generally, and it's often a warning sign that they've just gone too much the other way. They're not advocates. They're not really part of the team in the sense that everybody else is. So I would only have them at conferences on matters pertinent to their retainer, unless, obviously, I mean, there's always exceptions to that, but generally speaking, that would be my view.
Agree. Just Leslie, on that point, the incentivise, I think if you were going to go down the incentivise route, yes, transparency. But I think what you'd have to have your expert spell out in the report is, this is the agreement we've entered into. The reason we've had to enter into it is for X, Y, and Z. I am acutely conscious that I have a primary duty to the court. I do not believe that this agreement has compromised me in any way. I think that's a very key point to flag up on the reasons. Just one thing I was just linking in there with, I don't know whether Nigel has a view on this. I'm always loath to have experts at mediations as well, because I sometimes find that if you have experts in the room, they can become too entrenched in the views that they're offering, and they sometimes can get in the way of a resolution. You should go along knowing what your expert advice you've received is, what the ranges are, and they don't really need to take a part in mediation. I don't know whether, Nigel, you have a view on that.
On that point, Mark, I'm fairly evenly sort of minded about engaging experts at mediation. Sometimes they can do a lot of the work that perhaps an advocate can't, and they can help, they can tip, they can just nudge in the right places. It's when you get a bit of a power struggle going on in a room where you have both an advocate and an expert and trying to manage a client as well, that it becomes unmanageable.
Yeah.
On your other point, which I thought I entirely agree with about funding of experts and sort of incentivizing experts, I think it's a complete no-no. And I just put sort of my recorder's hat on. I know Leslie may have a view on this as a Deputy High Court judge, but if ever a court has to make a difficult finding on expert evidence, weighing very carefully the sort of competence, the compellability of two experts, once it becomes apparent that one has sort of been incentivized, you never know how subconsciously that's going to weigh in the judge's mind and just tip him the other way. So I think I'd express some real caution to solicitors about engaging experts on a sort of incentivized basis. It has a risk of backfiring, I think.
Nigel, I agree. I think it's not, as with all these things, it's not immutable in the sense that you could, as a judge, still be persuaded that the expert was not being influenced by the incentive. I think the point you make validly is, well, what's the starting position in the judge's mind? And the starting position should be, well, first of all, that incentive payments in this jurisdiction are not the norm. And secondly, that there should be an evenness of approach that the parties have taken to the expert. So I think my point would be, yes, you can overcome the difficulty, but you're immediately putting an impediment in place that doesn't need to be there.
I think that's
entirely agree.
just one issue which I didn't mention at all, because it's not really a pitfall, but there was the much maligned suggestion of hot tubbing of experts, and I think I've done 2 of those, and one in front of Miss Justice Norris. And I must admit, I'm a great fan of it, because it's quite difficult for the role of the advocate, because you're almost throwing in balls for your expert to hit and then ask the other side. But I do think you do see really what should be happening in the joint meeting, i.e. the experts bouncing off each other. Can you tell me why he's just said what he's just said there is wrong? And it's very difficult. You find that's when you really see the experts mettle in that regard. And I think it's a good idea that when you've got your own expert report and you're having a conference with your expert solicitors or counsel, is going through that sort of process. Now he says this, tell me why he's wrong. And often you find, well, he's not wrong. I think I can express a different opinion on that. And I think,
Mark, I have a great story about hot tubbing. I'll give it to you very briefly. Many
it is
years
about
ago,
expert evidence hot tubbing, though.
It is about expert evidence hot tubbing. Of course it is. Many years ago, I pitched up at Liverpool County Court on a 54-Act renewal, a disputed 54-Act renewal. It was down for 5 days. On one side was the late but great Ian Foster, such a brilliant property lawyer, great guy, against Tim Harry from London. I think I can start my video now. Yeah, against Tim Harry from London. And I hadn't been pre-warned when I pre-read the papers that they decided to hot tub the experts. So when I pitched up at Liverpool County Court, Ian Foster and Tim Harry got to their feet and said, well, Your Honour, we're going to hot tub the experts. Now, I hadn't got the foggiest what this was about. But in fact, as we worked through it, I had these 2 retail sort of experts. It was about a supermarket renewal, and it worked superbly. It really opened my eyes to the just thrashing through there and then the issues one after the other.
Absolutely.
So I'm a great fan of hot tubbing, and I know it's fallen out of sort of practical use these days, but it is very, very efficient.
I agree, and I think if you've got it's 2 very competent experts, I think you do really get a lot of common ground out of it, or it assists the judge in seeing what the issues are and what the factors are which could influence them either way in that regard. I think what we can take from this talk is, and I think which is I think people have really got to test their experts. You just don't have to accept any expert. And I think key is making sure you're going to have somebody who's going to be with you throughout the whole trial and understands the process. And I come back to, I'd rather have an expert who's telling us bad news at the beginning, as opposed to getting that bad news when they've gone along to the joint report and say, well, I had no choice then, did he? Because I couldn't really deny his point at that stage. I don't know whether there are any other questions, but thank you very much to everybody for listening, for my colleagues for joining in that discussion. As you know where we are if there are ever any issues like this that you need any assistance on.
Thanks very much, Mark. Thanks everyone for attending. And the next talk at 12 o'clock will be Paul Lakin on prescriptive rights. Thanks everyone. Bye-bye.